Well, thank you so much for inviting me to speak today. And, not much has changed in immigration at all. Yeah, so much has changed. I really had difficulty trying to figure out where do I even begin. So I think what I'll do is I'll talk about maybe 4 or 5 really big changes that have impacted immigration practitioners on a daily basis, and also open it up for questions, because sometimes that's where the real fun begins. One of the most recent cases that just came out of the shadow docket for the U.S. Supreme Court, and I should apologize in advance to the judges if I'm not quite talking about the legal analysis correctly, but you'll get the gist of it. I did print out the opinion if anyone wanted to see it, but there was a recent case, Vasquez Perdomo versus Noam, that basically this opinion allows ICE to use race, language, accent, location, and occupation as factors for immigration stops. So basically, it's giving a green light, temporarily at least. This is not a final decision, but it's giving the green light to racial profiling. The backstory is that a U.S. district judge barred agents from using this approach in Central California. You can't do this without a reasonable suspicion. In a 6-3 vote, the Supreme Court voted in an emergency request from the Trump administration and halted that California judge's order, preventing it, saying, yeah, it's okay to go forward. There was no majority opinion. In a shadow docket, my understanding is there's not a hearing, there's not full briefing, but it's just kind of a, hey, we kind of need this emergency ruling right now, and we'll clean all of the other stuff up later in a subsequent hearing. So there was no majority opinion. There was a concurring opinion. So Kavanaugh wrote the concurring opinion, 10 pages, but not to be outdone, Sotomayor published a 21-page dissent, joined by Kagan and Jackson. Basically, one of the things she said, the Fourth Amendment protects every individual's constitutional right to be free from arbitrary interference by law officers. After today, that may no longer be true for those who happen to look a certain way, speak a certain way, and appear to work a certain type of legitimate job that pays very little, because this is unconscionably irreconcilable with our nation's constitutional guarantees. I dissent. That was the end of the 21-page report that she wrote. So obviously, a lot of us are very, very concerned. And we're talking about a tough subject. I'm like, why did you get pulled over in Rockport or Ingleside, or especially Rockport? I stopped, and then I inched forward and I stopped again. So there were 2 stops. Or, basically I'm calling it, they got a DWB, driving while brown. I mean, and then that's what I am seeing, not so much in Corpus, but in certain other areas, and certainly a lot more nationwide. There's a chat room that only 16,000 of us are in, and so we hear all of these stories. So even though it's some of the stuff I'm not seeing myself firsthand, I'm hearing about it from the attorneys of people that are going through this. So this is happening. This is a real deal. This order is not a final ruling, but some people think it signals the future of this particular Supreme Court, and we're worried about it. I think many of you had heard about the attack on birthright citizenship. And a lot of what I hear when I tune in is, well, the only reason that we ever started with this was to work around the children of slaves, and that's how this all started. Well, that's not exactly true. Actually, birthright citizenship took its start from the English common law. Okay, so it's been around that long, and it's the principle of jus soli, I think it is. Basically, I say, citizenship where you drop. Okay, that's not as polite as it should be. It's the right of the soil. So if someone is born here, almost always they are a U.S. citizen. There are some exceptions, for example, for people that are here on a consulate visa. That person on a consulate visa from Mexico or wherever, wherever their baby is born, they are attached to that child, and so that child is not a U.S. citizen. This was ratified by came from the 14th Amendment in 1868, and it was part of the Reconstruction Amendment aimed at addressing the citizenship status of formerly enslaved people, their children. But the Supreme Court cases on this goes back as 1898, for example. There's a Supreme Court case talking about two Chinese nationals who had a child here, and what's the citizenship of the child. So even though the debates have intensified over this, a lot of us just think there's too much history, there's too much law, and that you'd have to actually formally amend the 14th Amendment. One of the biggest changes that has happened extremely recently, and it's very heartbreaking, is the rule about getting someone out on bond. It used to be if you'd been here more than 2 years, even if you entered without permission, you get picked up, you get taken to the detention center, and you have a right to the bond. And of course, the judge is going to consider, what is the flight risk? What is the danger to the community? And is there a path for this person? Because if there's no path, why would I let him out on bond? But at least you got to go before a judge, and the judge would, make the decision. If you'd been under 2 years, there's kind of, it's not exactly correct to call it mandatory detention, but it gives you a better idea of what's going on. If it's under 2 years, there's something called expedited removal, where if you were detained within maybe 20 miles and then it got extended and now it's anywhere in the US, but I digress. If you were detained anywhere now and you've been here under 2 years, you don't have a choice to have a bond hearing or even see a judge. It's expedited removal. Again, it used to be concentrated within a certain period of time in a certain 20-mile radius, and now it's anywhere. So okay, that's expedited removal. I see how they got there. Okay, what I'm having problems with, and this happened maybe 2-3 months ago is when this started. What happened then is, if I had someone that was over 10 years here, had a U.S. citizen child and or husband and or parent, you can do something called cancellation of removal for a non-legal permanent resident. You've been here more than 10 years, you're a person of good moral character, and then you have a U.S. citizen or legal permanent resident, spouse, child under the age of 21, or parent that would suffer unusual, uncommon hardship if you had to return to your country and not come back. So even if maybe I couldn't prove it up immediately, at least I had a shot at bond, and we could develop, see if we could meet that hardship criteria, which got tougher and tougher, but at least you could get them out on bond. So I had a person, again, this just happened, I want to say the case in July, still feeling pretty comfortable, even though the government attorney said, oh, matter of CLE applies. I'm like, I don't see how. This is all about someone who's entered the country, got caught entering the country. She's not eligible for bond. That's just kind of expedited removal. That's nothing like my case. My guy has, I don't even know, 15 years or something here, no criminal record whatsoever, et cetera, et cetera. I think I'm fine. They somehow use that case to basically say that anyone who entered without permission, the judge no longer has jurisdiction to hear a bond. They're considered arriving aliens, which if the person is an arriving alien and the box is checked, arriving alien, the judge does not have jurisdiction. But for someone who's been here for more than 2 years, the rule has been, you didn't catch them before and now we get a chance at bond. And so no, so I'm like, I've got to have misargued this. This can't possibly be what the case is. Well, it was. And they followed it up with a second case that basically said, if you are detained anywhere for any reason, even if you don't have a criminal record, even if, whatever, you don't qualify for bond, the judge doesn't have jurisdiction. But DHS will not work around us at all. So today I had a bond, and luckily she entered with permission. Judge has jurisdiction, no criminal record, single parent, 2 U.S. kids, 11 and 17, I think it is. So she qualifies for that cancellation of removal. So I was feeling pretty good about going forward. And I was asking for the minimum amount, which is $1,500, because I'm like, of course I'm going to get this. Judge set it at $10,000 and made a really big deal about, you knew when you came in, I mean, very strong language, right? You knew when you came in that you had to leave by a certain time, and you chose not to do it. You chose to, I mean, it was pretty strong language. But $10,000, just so you know, that's not normally what I see for this type of case. I thought, well, maybe it'll be $3,000, because, you know, but $10,000. So that was special. Mandatory detention, the expedited removal, which has been expanded, the lack of the judges having jurisdiction over bond proceedings if they've entered without permission, that has been really, really rough. So now, if they do have a case where they do have a 42B case, they have to stay detained. And I think that, I mean, I had an asylum client that, you know, in the past we could get around this whole arriving alien thing if an asylum had been filed. That's been lifted. That doesn't apply anymore. So this person who has a pretty decent asylum case filed by somebody else, 5 family members killed. I mean, this is a decent case. She's like, I can't stay here for 4 or 5 months. I just can't. And so she's going to waive her right and withdraw her case and be deported back home. That is what appears to be the reason behind some of these detentions, is we don't have to give you bond, and we're going to make your life miserable, and you're going to have to stay detained for 4, 6, 8 months. And, you know, if you want to go home, it's okay with us. Then the one other thing that happened, and again, here I'm kind of enjoying kind of moaning and groaning about this, but seriously, I mean, you have to understand what this climate is like right now. When you go into court with someone and you have the government attorney, and these are attorneys you get to know after a while, and this has not happened to me, but it would happen so often. I've changed my way of doing things. You go in there and the government attorney might say, especially in a decent case, listen, the government has no intention of pursuing this case. We'd like to go ahead and agree to a dismissal, which usually is really good news, right? So this was happening. And then what would happen is the clients would walk out, no longer under the court's protection. Any guesses? Anyone? And ICE was waiting there and would arrest them. And now they don't have the authority to see a judge because maybe they were here less than 2 years. Okay, now they're under that expedited removal. And I just thought that was very disingenuous, and I felt that was, you know, that's not playing fair. I mean, at least give us the rules. Whenever possible, I don't go to court with my clients. I have them come to my office to these cases over the internet. So I'm happy I don't have to drive 5 hours, you know, 2.5 there, 2.5 back for a 15-minute hearing. That's really, I love that. But there's no ICE officers yet waiting outside my door. So these are really big changes, and this has been in the last 3-4 months that all of these changes have taken place. So I'll give it, and I know Maria Pia probably has the same thing. She'll give advice, and then she'll see something like 2 hours later, and then she'll call back the client and say, JK, that's not what has happening anymore. We were just talking about another big change that has happened, which is an H-1B visa program, which is also referred to as the professional visa, where you have a minimum of a 4-year degree and you're in a job that requires a 4-year degree. So attorneys, doctors, teachers, accountants, you know, professionals. And we would do a lot of these. They offer $65,000 a year. About 200 to 300,000 apply a year. So now it's a lottery situation. What was it, 2 weeks ago? Just out of the blue, I didn't hear any mumblings about it. Huh?
On a Friday at 5.
On a Friday at 5. Yes, exactly. Exactly. The new rule is, we're still going to let you do this, but we're going to increase that fee from maybe $1,500 to $100,000. Starting Sunday. I mean, there was no chance to like dive in and do, 24 hours straight of, fixing your clients. I mean, So this isn't going to work for a teacher who's earning $60,000. The school district's not going to, they might need a special ed teacher. Again, it feels punitive. I want to talk about TPS, which is temporary protected status. This is something that's been in the news a lot, but I don't know if everyone appreciates kind of what's going on. This TPS is a program where if it's felt that it's not safe or it's too difficult to return to a person's country, either because of civil strife or an environmental catastrophe like the earthquakes or the floods or whatever, then they can apply for TPS. And so a lot of people have TPS, and their work permits, they'll get work permits are let's say they're good until April of 2026. Well, so what happened is there's about 10 countries where this administration just went ahead and terminated everything. Okay, so these are people that they didn't enter with permission in this particular case, but they got permission to be here and they have work permission. But the termination, in most cases, didn't last until the end of their work permit. It just all of a sudden said, boom, you're here without permission. Now you're subject to deportation. And I felt like, again, this needs to be a little more common sense, a little fair. If someone knows that, hey, this is temporary, but I have until my work permit expires, but all of a sudden a year earlier it's cut off, that makes things a little tough. It probably affected, about 1.5 million people. There was a program where you could actually log into something called CBP1 and get permission to come into the US for this type of program, something similar. So they've entered with permission, they've gone through it, then all of a sudden that program has been discontinued, and to hear certain government officials refer to them as, they're illegals. I'm like, well, they came in with permission, they came in how they were supposed to. With a swipe of a pen, you've terminated their status.
It's not going through the usual, there's a law that's passed, and then they allow the executive agency to, in effect, do the rules and regulations for the implementation. And that usually means the rules are posted, and there's a period of where you can go in.
Oh, you mean like the legal stuff?
Sorry, is the ICE woman just putting her pen and saying this is it?
No, seriously. Yes, that's what I think is very, in a way, heartbreaking for the practitioners. Is we have no warning. That $100,000 thing, normally when you have a price increase, it has to be posted in the Federal Register, 60 days for comments, yada, yada, yada. Boom. Got it Friday at 5, implemented Sunday. And that's just happening over and over and over again. Let's talk about DACA. Let's talk about kids. Let's start off with the easy one, which is not easy. Deferred action for childhood arrivals. This past June 15th, 2012, which I remember specifically because I was at an immigration conference, the national one. I think we were in Las Vegas. I can't remember. I just remember it was this big, huge room of, 6,000 of my closest friends. And the president comes on and announces it, and the shouts and the tears of joy that went up, because this was a long battle to try and get the dreamers, the kids who had come here at age 2, 4, 6, under a certain age, to get them to be able to start living an American dream and go to college without fear of deportation and yada, yada. It was incredible. It was really incredible. And so to qualify for that, I won't go into everything, but generally speaking, you have to have been here before 2007. And you have to have continuous presence since 2007. Good moral character. You can have a misdemeanor, but not, don't do more than 2 misdemeanors. I mean, and even a misdemeanor at this time would be really tricky, depending on the misdemeanor. But you have to have a really solid non-criminal history. You have to have graduated or in the process of graduating from a high school. It's a program that doesn't punish the kids for the sins, if you want to call it that, of the parent. Okay, they did not make this decision to come in. There's nothing wrong with wanting our youth to be educated and to contribute to society. And this is what that did. This was an executive order, okay? unfortunately, because what one person gives, another person can take away. It is what it is. I wish that we had more bipartisan support to actually make this legislation. Maybe that's what will happen with some of this going on, but it hasn't happened yet. Challenges started saying that this was unconstitutional, this was damaging to certain, states. Yeah. So what happened a few years ago is they would renew the DACA permissions for people and work permits for people who had already applied, but you could apply, but you could no longer get your petition adjudicated if it was an initial. We'll just keep it. So I would still file initials because I'm Pollyanna. This is all going to work out. Okay, this is going to work out. It hasn't so far, but I digress. So anyway, the Fifth Circuit had an opinion recently that says, okay, this is what we think we're doing, and that we're waiting for the judge's order as we speak. We think it'll be in about a week or so. But we think what's going on is DACA, with the exception of Texas, DACA remains intact. People can renew their status. They can renew their work permit. And even the initial applications that got filed are going to start to be adjudicated. It hasn't happened yet, but they keep saying it will, but it hasn't happened yet. But what we think is going to happen with respect to Texas is they will get the extension of the DACA status, but they will not get their work permission. Even if they've had it for, at this point, 13 years, they're not going to be able to renew it. Now, we're hoping that that's not the case, but we're thinking it might be the case. The government has indicated that what they will do, because they're trying to be fair, is they will, before making a decision on whether or not the work permit will be approved, they'll send out a letter verifying the person's address. If they're living outside Texas, then they might go ahead and give it. But again, we don't know yet for sure. Judge Hannon, I think it's in front of him. He's not been warm and fuzzy. So
you have legal status, but you can't work.
Yeah.
So you just exist.
It's limbo because
Like
it's
yes. You can't contribute. You can't make a living.
Not in Texas. But you can move to Oklahoma.
Okay, well maybe that's an option.
Just saying.
I mean, that's crazy not to be able to work.
I don't see how that helps us economically in Texas, but that's just me. Only Texas right now, the judge's order says that the other states that joined in didn't prove to his satisfaction that they would suffer economic harm. But Texas did. Talk about kids. There's a program that started a week ago, Freaky Friday. Did you hear about that one? It's called Freaky Friday because, names are important in this business. This is a program that offers $2,500 to unaccompanied children, 14 years or above, if they waive their rights and self-deport. So the children would waive their rights to appear in front of a judge in exchange for $2,500. Now, I don't know about you, but my 14-year-old would say, where do I sign? I'm an American citizen, but $2,500, give it to me. I'm especially concerned about the trafficking victims. They have a way to fix here, okay? Under the TVPRA, I think it is, Traffic Victims Protection Authorization Act, Reauthorization Act, that's what it is. There's some protections built in, but now you're offering someone $2,500. Very discouraged by that. The other thing I'm discouraged about is that this is civil law, not criminal law. You have a right to an attorney, but if you can't afford one will not be appointed to you, okay? But there are grant programs that are in place. Some of them are federally funded, others are not. All the funding has been cut off. So I think that affected about 26,000 kids right now who had attorneys under this federally funded program because we thought as a country, whether we want you here or gone, you at least need, because you're 14, you're 15, you need someone to help you through this process. And we thought that that was who we wanted to be as a country. And now that is gone. 90% of the kids who are unrepresented get deported. Just saying. This is happening. They've lost their attorney. They're a 5-year-old or a 7-year-old or an 11-year-old that's now in front of a judge, and they don't understand the legal process. I didn't understand the legal process until I probably had, a dozen trials under, hearings under my belt. And you're going to send in this 11-year-old with no education and they're scared? I just, that's not what I want. Well, even with all this, I really do love what I do. I like fighting for the families, and I love hearing the stories. Thank you very much.
Thank